All rise. The Court of Appeals, Division 1 is now in session.
Please be seated. Good morning.
Good morning.
We are here for oral argument in case number CV210581, Milham v. Milham. Each side has 20 minutes for argument. Appellant can reserve some, but just I would ask keep track of the time. Proceedings are being recorded, so if you could introduce yourself, it would be appreciated. We've read the briefs, conference the case, and with that, counsel, you may proceed.
Ray Dietrich for Mark Milham, the appellant. May it please the court. The 1998 divorce decree and all subsequent court hearings place no legal obligation on Mark Milham, the retired military member, to make direct payments to the former spouse until such time as that designated agent, the government, DFAS, makes those court-ordered payments. In 1998, the decree awarded the former spouse a little bit over 32% of Mark's military retired pay. And that was based on his active duty service back in 1998. And they sort of projected it through
Counsel,
20 years.
I want to clarify exactly what's before us. Do I understand correctly that what you have appealed is just the judgment itself? You did not appeal from the clarifying order that the Superior Court issued?
That's correct, ma'am, because we consented to that clarifying order.
Right.
And that's actually the key of the case because it modified the terms of the decree like Kubaska did. So we just we appealed the judgment.
Right, so you consented to those modifications?
Yes, ma'am.
Okay.
Yep. And that is the key because that decree awarded a little bit over 32. It was 32.43% based on active duty. The problem is there was a change in Mark's career as a fighter pilot, and he ended up going to the Guard. So subsequently, that moved him to what's called a point system. So when we came back with the former wife's petition back in 2001, about 23 years later, we had to do some adjustments on the percentage that was awarded because it was based on points, not active time. So what we consented to, as what you just pointed out, Judge Perkins, is a clarifying order. But it changed that award. It changed it from the 32 to 31.5%. And that is the turning point, at least in my mind, on how the case should be analyzed, because that modification, just like an award was modified in Kubaska, it takes us out of Kelsch. And Kelsch is an old case that the bar and the bench relies on heavily. And in a nutshell, Kelsch basically, in my opinion, gives carte blanche rights to a former spouse. Whatever you are awarded, you're going to get it, no matter what happens afterwards. And the bench is pretty easy and quickly to sign off on orders. It just awards what was done. And this is all post-decree. So what we have here, we moved from Kelsch to Quijada, because that's a recent case of this court that said post-decree modifications our main statute, 25-318A, do not apply to post-decree modifications. And that's what we're at. Because it distinguished Kelsch, it said they have this automatic present interest in a retirement plan at dissolution of marriage. So that was a timing issue of Kelsch versus Quijada. So we're out of Kelsch and we're in Quijada. And since 25-318A, and we're not at dissolution of marriage 23 years later, the former spouse should only get what the court ordered. She doesn't have that immediate present interest going back 23 years.
But the court has now ordered under the clarification order something different, and that's what she should get, correct? What you have appealed from, the judgment, was an enforcement of that clarifying order.
I know the court classified it as enforcement. I don't see it as enforcement. I see it as a modification because we actually did change that award.
What did the judgment modify?
Say that again?
So you've appealed from the judgment, not the order. What did the judgment modify?
The judgment modified the exact amount, the percentage that former spouse would get of the military retired pay.
Actually, that was the order. The order changed the percentage.
It
The
did.
judgment is an enforcement of that new percentage, correct?
The judgment is going back and enforcing basically that present interest that was awarded to that former spouse at dissolution of marriage. Even though the percentage has changed, they're going back and saying from the time that he retired, even though you didn't submit this court order, and it should have been submitted, if we could just get down to the brass tacks, and I put it in my brief, the court order should have been, for military, should have been put in with the decree. All of these quadros and assignment orders need to be entered with the decree, but in very few cases they are not. So she sort of opened herself up to that, and in the transcript at the hearing that I also cited in the brief, she said she assumed that everything was done. So to me, that's what turns the case, is that modification. She doesn't have that present interest. We have Quijada, and I ask that we enforce Quijada, because it significantly, in my mind, distinguished Kelsch from this carte blanche, you get whatever you get at dissolution marriage. Okay, we're not at dissolution, you modified the decree, and now you should only get what was awarded to you. And going back to this obligation, the legal obligation, the Superior Court currently could have easily said, you start making direct payments, but they didn't. So the decree did not award or order direct payments, nor did any subsequent hearing, and that could have been easily done. And if that was ordered, I don't know if we would be here right now, because that's part of my core argument. There's no legal obligation on Mark to make those payments when the onus is on the former spouse.
But she, correct me if I'm wrong, counsel, mother did take steps to get payment. I mean, isn't that correct? Didn't she approach DFAS and say, DFAS, hey, here's an order, give me what the court ordered me back in 1998? Did that not happen?
Because the order, that's correct, she took steps about 23 years later
To do it directly?
to do it direct, and there's nothing in there that says you pay me until such time as DFAS pays out directly. So she submitted that order, that's correct,
Okay.
but there was no order for Mark to fill that gap until such time it's paid out. And that's sort of...
But even if he wasn't ordered to pay her directly, that was her money. The fact that he wasn't under orders to pay it directly to her is why the court then entered judgment saying, okay, well, you didn't pay this to her, but she's entitled to it under the division in the decree and clarified at this different percentage. So judgment for those money damages that the husband retained but that were owned or were the property of wife.
Again, the distinction is, though, because of the modification, it takes us out of that. She has an interest in that from dissolution, and it goes to the modification under Quijada. So we have Quijada. I just hope we use it because it modified it, and she doesn't have that carte blanche, I get whatever was awarded to me in 1998. But it also leads to my alternative argument, too, and I cited what they do in California under Carnejo and then in Henson in Nevada. As an alternative, perhaps consider, and I think she should just get what was ordered through the court order, but both of those cases say she doesn't, the ex-spouse, former spouse, doesn't get anything until she makes a demand. And that's how they handled it and because we're under a modification, again, we're not under Kelsch going back to dissolution. If perhaps we didn't have a modification, perhaps that argument would be weaker. But in Nevada and California, until you make a demand, and they say you have to file a motion, not a letter,
Counsel,
not an email.
didn't she make a demand, though? Didn't she tell your client, hey, you're going to retire, you're going to owe me the money under this decree? So pay me that money. And then my understanding is the response was in the negative. So there is a demand. I mean, notwithstanding it wasn't brought to a motion, but is that not a demand?
It is, but both of those cases and how they approach it in California says that's insufficient.
So a demand to the party is insufficient. A demand has to be made to the court?
Yes, sir, under Cornea and Henson in Nevada.
So if someone has a present obligation, a vested interest in something that is in a property, a corpus that is held by someone else, what you want us to say is it is insufficient for you to go to the person who has that corpus that includes your property. It's insufficient for that person to say, hand me my share of that property. You have to go to the court and say, make me?
According to Cornejo and Henson, that is correct, because and I put it in my brief, it establishes a clear, bright line on the demand. And
Those are the California and Nevada cases?
Yeah,
So we don't
Cornejo.
have that here in Arizona. Our court hasn't declared that to be the state.
No,
here.
ma'am.
Okay.
I brought that in for you to consider to adopting. They're both community property states right next door to us. But you're right, that is an insufficient demand, and those are the holdings of those two cases. And that's the position currently of Nevada and California.
Would that not be cause a cause of expanded litigation? If all parties know that, no, I don't have to give you your property that you have a vested interest in because you haven't asked the court to make me? Doesn't that necessarily lead to increases in litigation?
I guess it could, but that's the holding of those two cases in the state position. I'm licensed in Nevada. I just did a similar thing. I filed a motion, and they paid because it was in court. They got served, and we resolved it. So it could also be viewed as an incentive to meet your obligation. So I think it could cut both ways. The Rule 85, I brought that up because it's untimely for direct payments. The petition asked for direct payments. We're well beyond 6 months from 1998. I don't see how the other factors of Rule 85 apply. So I tied the Rule 85 to direct payments.
The Superior Court didn't analyze Rule 85, is that correct?
I did. It didn't appear to. Yeah.
Okay. But the Rule 85 would apply again to that clarifying order, what the court did in the clarifying order in terms of whether or not to allow the modification.
No, not the modification. The Rule 85 applies to the direct payments that he's to pay her until such time as DFAS, as that designated agent, pays out. Because it was never ordered in a decree, nor any subsequent hearings. So she's trying to modify that to say you make direct payments until such time as I get my payment. I cited a Virginia case, not to go too far to the East Coast. They said if you make a request for direct payments and the court denies, that's error. So she could have easily requested direct payments at any time, even in the decree. But again, the order should have been in the decree. It would have been flagged when he went to guard, et cetera. There would have been no gap because it would have been approved by DFAS and paid out. I know going back in time, I just want to make also a laches argument because there is some detriment. I think we all can agree that 23 years is a little belated, but also detriment. And as testified to Mark, and he's had to finance the $32,000 bond that we posted for that judgment.
Now, he had noticed that wife had not abandoned this interest in this retirement, right? I mean, from beginning. Before he received a single check from retirement, he was on notice that wife was pursuing her share of it, such as it was.
He retired in March of 2020. I'm not sure what he knew and what he thought. The petition was filed in 2021.
So you're saying that her counsel never contacted him before that?
I'm not going to comment on that because I wasn't involved, so I would just be speculating.
Okay, but there's nothing in the record that says anything about that?
I think Mr. Riley will probably make his own argument, and I'll let him make that, but I'm unaware. I came in after that petition, so I don't know what went on before that and what his state of mind was. in the way of notice, after 23 years. And I'll reserve my 5 minutes if there's any more questions.
Thank you, counsel.
Good morning. I'm Daniel Riley on behalf of the appellee, Sandra Wohl, formerly known as Milham. As I was listening to counsel's argument, I was reminded of something that Professor Birch told me on the very first day of law school 15 years ago. He said that you'll notice in your career as you go out that when you're on the right track, you'll be able to take complicated issues and make them simple. If you find yourself making really simple issues overly complicated, you need to stop, go back to the beginning, and reevaluate things. This is a very simple case. The decree awards my client a portion of the husband's pension benefits. Through no fault of either party, the DFAS transmitted those pension benefits to husband, and the court ordered him to return it. That's it. It's a simple case. The arguments that we've heard are first that husband had no legal obligation to return the money. This flies in the face of 60 years of legal precedent. Over and over again, this court, the Arizona State Supreme Court, has repeatedly explained that trial courts have broad inherent authority to enforce their own orders. This notion that the trial court's authority to enforce its order should be circumscribed by the specific reservation of power in the order, it finds no support in the law. And you don't need to think very hard to come up with all the different ways in which this would introduce chaos into the court system. If you were setting out to intentionally create a system that would motivate people to participate in gamesmanship, that would require judges and attorneys to have to micromanage every financial transaction in a family court case, you would struggle to find a better tool than the one that is being argued by counsel here.
So, counsel, what is your response to the centerpiece of your colleague's argument, which is Quijada, that answers this case? What's your response?
This case is not a modification case. In Quijada, the issue was that the former spouse, in both the decree and the domestic relations order, which had been submitted at the same time, there was a clause in both that said that the wife would receive her share of the retirement at the same time and in the same manner as the husband. And the husband elected to continue working. The wife filed a post-decree petition asking for direct payments pursuant to Kelsch versus Kelsch. The direct payments under Kelsch are available when there's an interest in a pension. For whatever reason, the pension is unable to make those payments to the alternate payee, typically because the employee spouse is electing to continue working, and the alternate payee is asking for direct payments in lieu of those funds. The trial court denied that, saying that because the decree said that she would receive her share of the pension at the same time and the same manner, that she could not then come back years later and ask for a Kelsch payment. It was appealed, and this court affirmed that ruling on appeal.
Counsel, you say that this case is not a modification case, but
Correct.
the clarifying order modified the percentage, correct?
No.
Okay.
Here's what
It
happened.
was a different percentage, so explain to me how that was not a modification.
Here's what happened. The decree says that wife is awarded 32.43% of federal retirement monies received from active duty service. But what happened is after the decree was entered,
Right, he
husband
went to
then
the
went
Guard.
into the Guard and accrued a small amount of pension credits through National Guard service. So the clarifying order then states that she's awarded 31.5% of the entire disposable retired pay. That 31.5% of the total pay is 32.43% of the amount accrued from active duty service. It's not a modification. That argument fails on the facts alone. It's also legally not a supportable claim. No motion was made for relief from the judgment here. The petition that was filed was a petition to enforce, specifically cited Rule 91, not Rule 85. The court, in its order, specifically explained that it was enforcing the orders. It was not modifying anything. So that argument fails on both the facts and the law. The latches argument Again, this is another claim that fails on both the facts and the law. A laches defense requires proof of two elements. First, that there's been an unreasonable delay, and second, that it has caused actual prejudice to the other party. Not detriment, which I think is the word that counsel used, but prejudice. And what the law says is that prejudice means that it has interfered with that party's ability to defend against the claim in some way. This can come up, for example, if records that could have been used to defend against a claim have since been lost because so much time has elapsed. Husband has never argued that his ability to defend against this case was prejudiced in any way whatsoever. At trial, he said the only detriment that he was suffering was that he had already spent wife's money. And frankly, that's not a defense, that's an admission of wrongdoing. So the laches fails on the facts. There's also direct case law on point here. Flynn versus Rogers was a case that also involved the division of military benefits. That was a case that happened during a brief window of time between the U.S. Supreme Court's decision in McCarthy, which said that the anti-alienation provision in Title X means that state courts are not permitted to divide military benefits in a divorce. And then years later, Congress then amended that to make it clear that no, this is community property, and state courts are permitted to divide this. And that act was retroactive. So in Flynn versus Rogers, the former spouse came back years later, filed a petition to divide not only the future benefits, but also for arrears that had accrued over that past period of time. This went up to the Arizona State Supreme Court. The Arizona State Supreme Court said very clearly that if a person has notice that the alternate spouse has a right to these benefits, then there is no laches defense. Laches does not apply.
If we're looking, let's take for a moment that we're in the modification world of Rule 85, and I think it's 6 that talks about a reasonable time. From what point do we measure that? Is that from the change in branch of service? Is it from 2016 when I think that was the start of the effort with DFAS? At what point would the court need to look to determine whether the time was reasonable from wife's perspective?
It should look at the date, Your Honor, at which DFAS rescinded its initial approval of my client's application for benefits. So while Mr. Milham was still in the military, had not yet retired from service, my client did what she was supposed to. She submitted a certified copy of the decree and all the appropriate forms to Defense, Finance, and Accounting Services so that they would know when this person retires and we receive their file, we now know we have to split it in this particular way. This statement that was made that DFAS would have received notice when husband entered the Guard, that's just factually not correct at all. DFAS does not receive any records until a person retires. Whether they're switching from active duty to Guard service, DFAS doesn't receive that sort of notice. And this case proves that because husband switched from active duty to Guard service and DFAS did not receive notice of that. They only learned when husband actually filled out his paperwork to retire, and that is when on June 15 of 2020, this is Appendix 4 of our answering brief. On that date, DFAS contacted my client and let her know that they were rescinding approval of her previous application. And within 2 weeks, she had retired counsel and had sent Mr. Milham a letter from her counsel explaining, you're going to start receiving 100% of these benefits. It's not all your money. 32% of that belongs to Ms. Wool. Either submit that to her or set that aside. So there was no unreasonable delay. There was a 2-week delay from the date that my client received notice that DFAS had rescinded her application to the date she began actively attempting to communicate with husband to receive those benefits.
When did wife first have notice that husband switched from active duty to Guard reserve duty?
I don't believe this was established in the record,
Okay.
but it was on June 15, 2020 when she received the notice from DFAS stating they needed a clarifying order. And the reason they needed that clarifying order was because DFAS calculates retirement benefits differently, whether someone retires from active duty or from Guard service. So when someone switches from active duty to Guard and then retires, there's a different calculation than if they had retired from active duty. So because the decree said that she was entitled to 32% of the active duty component, DFAS said they didn't really know what that meant, and they needed her to obtain a clarifying order from the family court. The trial court also awarded my client fees. We're also asking for fees on appeal here. The positions advocated by husband in many cases are directly contrary to law. They're not reasonable. And as the trial court found, there is a significant disparity in the resources of the parties here. My client earns $49,000 per year. Mr. Milham earns $259,000, over 5 times the salary that my client earns. We're asking for an award of all fees and costs.
Is that enough? Let's talk about that. So I think the other side is arguing maybe for an extension of the law, so something we don't recognize. In Arizona, is that unreasonable? Number one, well, what's the answer to that?
Well, what he's asking for is not an extension of the law. The Nevada and California cases that he's citing, those are cases that involve what we would call Kelch payments here in Arizona. This is not a Kelch case. No claim for Kelch payments was ever made in this case, nor could one have been made, because Barron v. Barron preempts Kelch payments in the context of military benefits. Those cases arose on a post-decree posture where someone came back years later and said, my former spouse who's an employee, they're continuing to work, they're delaying my share of the benefits, and I would like to receive direct payments. And in those cases, California and Nevada said you're entitled to direct payments, but only going back to the date at which you requested your petition. That's the valuation date for purposes of the direct payments and for calculating any arrears judgment. This is not a Kelch case. This is a case in which the husband, spouse, he didn't continue to keep working, and my client came back and had discretion as to when she was going to ask for the payments. This is a case where he retired from military service. He retired knowing there was a decree saying that 32% of the benefits he was going to receive belonged to another person, and he kept it month after month. Then he stipulated to change the percentage from 32% to 31%, and then he continued to keep it month after month until finally Defense Finance and Accounting Services implemented that order and began paying my client directly. That is not reasonable. This notion that the court must specifically include in the decree what should happen if one party receives property belonging to another. Think of all the cases that would come up on appeal if your honors were to accept that. Your next appeal would be a case involving the sale of a home, because this happens all the time in family court. There's a closing on a home, the decree says how the parties are supposed to split the benefits, then a few weeks later, typically a check arrives for a refund of private mortgage premiums. Under husband's theory of the case, it's finders keepers. Whoever gets that check just gets to keep it. Doesn't matter that the decree said they were supposed to split the proceeds in any particular way. It didn't specifically say what was supposed to happen.
I believe, counsel, your opposing counsel's position more precisely stated is that it's on the person with the interest to approach the court and say, make them give it to me. So I don't know that that's necessarily a correct characterization. Go on.
No, and that's what happened here. My client did attempt to settle the case when husband didn't cooperate with preparing a clarifying order. It became clear he was not going to voluntarily remit any money. My client did file a petition. Why would we punish people for trying to resolve issues before filing a complaint with family court? Why would we want a system in which people have to rush to the courthouse door without first engaging in some kind of good faith process to try to resolve disputes? That process, to me, it doesn't make sense from a policy point of view. It doesn't make sense from a case law point of view. There's no case law to support this notion that you lose your interest that's awarded to you in a previous court order if you don't immediately that very month go to court to try to enforce it. In fact, this court has recently held in multiple cases that statutes of limitation don't apply to property awards. The judgment renewal statute doesn't apply to property awards. This court has repeatedly thwarted claims like that have asked that there be a time limit imposed on someone's right to come back to court and ask for the property that was awarded to them in a prior order. Did your honors have any further questions? Thank you for your time. I don't have anything further to add.
Thank you. Counsel.
Counsel, it appeared to me, contradicted himself on the points. He first said if you do a points versus active duty, it's the same. Her 32 is the same as 31, but then said it's a different process, different procedure, you're going to get a different amount. So I felt like that was a contradiction. It is a modification of the amount, and that's what Kubaska did. It is a different amount if you based it on active duty service and time versus going into
Counsel,
guard.
let's be completely clear on that, though. What you're saying, though, is that it's a different amount of percentage, not a different amount of money. Is that?
It will be a different amount of money because it's a totally different scale and different system because he's not active duty, he's just on guard, and then he goes to points.
But you're not arguing seriously that she's not entitled to anything simply because he switched to guard rather than from active duty.
Well, of course not, and we consented to the modification based on the reserve points and got that from that 32% down to 31.
Which is meant to account for the time that was spent in the guard where he wasn't married to her, correct?
Right, it's in there because we have that coverture. We haven't appealed the time rule and all that. So that denominator does have time in the guard, not married.
Right, so it's meant to reflect the time in active duty.
It is not active duty, so I beg to differ. It's based on points. And it's based on...
I understand why that, but what we understand, maybe this isn't correct. What I understand is that he had a specific tour of duty in the active force, in the Air Force, then transitions to the Air National Guard. The Air National Guard then, when he is ready to retire from the Air National Guard, says, well, when you're from the Guard, we figure that based on points, not on time.
That's right.
But his active duty retirement didn't just disappear.
No, it didn't, and it's part of the calculation.
As part of the points.
That's right. It is part of it, yes.
Okay,
sir.
so then is the argument then that there's some sort of alchemical transmutation that puts that beyond what it was?
It's a modification because it actually changes the amount, and that's what this court found in Kubaska. So it does change the amount. We're modifying the amount, both percentage and the dollar amount, because he's now in a point system that goes to the former spouse. So that's why it's a modification of the decree, which set it up based on active duty 20-year service. So that never happened. The other thing, Weinstein on latches, it talks about prejudice. That is used in there, but it doesn't define it. I think when you have to incur debt, that's a prejudice to a party to come up with $32,000 on a past arrearage.
But your counsel just said that wife's counsel had told him before retirement started, I'm pursuing my share of the retirement. So he was on notice, at least in my view, that before he received a single dime, that part of this money was in dispute. And we can quibble on what that is, but he knew that a claim was coming.
Counsel admitted that's not in the record, so that was his comment here at oral argument. I wasn't involved with that, so I would be speculating on what Mark knew, when it happened, etc. I came in when that petition was filed.
But we can agree that at a minimum he knew from 1998 that wife was entitled to a percentage of these retirement benefits. And we can also agree that when he started receiving 100% of the benefits and had that knowledge that he, at a minimum, should have known some percentage of that money might be in dispute, right?
I think so. I think that's accurate, yeah.
Okay.
And then, on the two cases, counsel is right, those were direct payments, but I think we could still use that analogy, at least what the courts did, and I think they would probably apply it to this fact scenario on filing of the demand in court. I know that hits you wrong, litigation, et cetera, but that's the position they take. But I think we can easily extend that, what we call Kelch direct payments, to arrearage payments, especially going back to 1998. The other thing I just want to comment, I've got 1 minute. DFAS, the file wouldn't be tickled when he went to guard. I didn't say that. But it would be tickled 90 days prior to his retirement, and they would have notified her if they would have had a original order on file. In other words, he's retired, hey, we've got this assignment order. Well, wait a minute, he's now in guard, not active duty. So it would have been tickled, the file, and DFAS would have reached out prior to implementing, allowing him to retire. So I just wanted to correct that. It would be tickled when he changed. They're not involved with that. Thank you.
Thank you both. Thank you both for your argument. We will take it under advisement and have an issue a decision in due course. And we'll get ready for the next argument.